Good afternoon, everyone, and welcome to today's webinar. In March, FPSA released our latest member benefit, the Sales Contract Resource Guide. The guide is a members-only tool, and today we have Barbara Dunn O'Neill with us to walk us through the different sections and answer any questions you may have. Barbara is a partner with the law firm Barnes & Thornburg. My name is Dolores Alonzo. I'm the VP of Membership here at FPSA. And a few things, this webinar is being recorded, so you and any of your colleagues will have access to it in the members only section of the FPSA website after today, should you want to listen to it again. There are 3 documents which you can access in the attachment section to the right of your screen. One is the Sales Contract Resource Guide if you haven't already downloaded that. Secondly, the FPSA antitrust guidelines for our meetings. And the other is some information on one of our affinity programs that is sponsored by Barnes & Thornburg. It's our legal services program for FPSA members only. Barnes & Thornburg specializes in many areas in addition to contract review and negotiations, such as intellectual property, customs compliance, and trade regulatory counseling, labor and employment, and cyber liability and risk management, to name a few. All the information is on the attachment regarding the program benefits. So before I pass this over to Barbara, I want to just cover a few housekeeping items for today's webinar. All attendees are muted by default, but you have the opportunity to submit any text questions to Barbara today by typing them in the questions pane of the control panel, I believe to your right. Send your questions in at any time during the presentation, and Barbara will be happy to address them. So thank you again for your time today. Let's get started. Barbara, I'm going to pass this over to you now.
Great. Thank you, Dolores. Good day, everyone. It's a pleasure to be with you. Thank you so much for joining us to discuss the Sales Contract Resource Guide. I have the pleasure of working on the guide with the FPSA staff and with a lot of input from your FPSA leadership. So as Dolores mentioned, we'd love to have your questions and comments throughout the program today. Please type them in as you think of them. We're going to stop and take as many questions as we can along the way and make sure we leave time at the end for additional questions. One thing I wanted to highlight, as Dolores mentioned in the attachments, one important attachment which you see noted right here off the bat in the introduction section is our antitrust guidelines. So while we'll be talking about, in general, certain contract clauses, what they're for, what are typical challenges in negotiating, et cetera, we won't be talking about specific terms, so pricing, terms of warranty, et cetera. Under our guidelines, it's prohibited that we have that type of discussion. So if you're not familiar with our guidelines, please download those and take a look at them. But again, we welcome your questions and comments throughout the program. So I've designed the program today to essentially walk you through each of the clauses in the Sales Contract Resource Guide. There's commentary included in the hard copy, and I'm going to make that commentary come alive a bit, if you will, as we go through our webinar today to share with you some comments, best practices, perhaps some tips and traps as well for each of these clauses. So again, understand as you share this, and please do share this guide with your colleagues. The introduction section includes that notice regarding our antitrust guide and also with regard to how the contract is used. That this certainly isn't a substitute for the guidance of your own legal eagles, lawyers, in-house or outside. So please run this past them if you're going to modify any of your provisions in your current contract. All right, well, let's get started and talk first about the introductory paragraph of a contract. Sometimes the introductory paragraphs vary. This one is just a sample that you can see on the next slide of how the introduction paragraph is set up. So a couple things I want to note as we switch over to the next slide. When you're selecting a heading for your agreement, we define terms like agreement. We define terms such as seller and terms such as buyer. Whatever terms you use, one thing I see quite commonly in drafting is an error in that we define something as one term and then we don't use that term consistently throughout the document. So for example, we may call it at the beginning the agreement, and then throughout the document we may slip into calling it a contract or something else, and we don't use that term in a capital letter as it's defined. So typically, capitalized letters mean that there's a defined term in that contract. And some of your legal eagles might have put all of your definitions together for those contract terms in one section. Certainly that's one way to draft it. Another way is to define terms as you go. So the heading, this introductory paragraph, is an example of that as well. So a couple things to point out. Obviously, it's important to insert a date in that paragraph right off the bat. Well, contracts, and usually in signature lines, we reference to dates that individuals signed a contract. I find that it's often helpful to just date the contract itself. And in some contracts, that date is actually going to be termed the effective date of the contract. So rather than say that one party signed on May 29th and the other party signed on May 26th, we actually say that the contract is dated May 29th, 2018. So make sure that date is in there. Now, when you're listing the parties, it's very important to use the legal name of a party. So a lot of you probably have long legal names of your company, but you might use a shorthand name. You might use a DBA, doing business as, or sometimes known as a fictitious business name to call your company. That's all right to do. Obviously, each state has different rules on registering those names, but what's important for purposes of this agreement is that you list the legal names of both the buyer and the seller. And that's important to list for a number of reasons, among which is that our goal with the contract is that we want to legally bind the other party. So having the appropriate legal name sort of takes out the potential down the road that someone might say, hey, we don't have a contract because you didn't contract with me in my corporate name. And also legally, and from a liability standpoint, contracting a corporate name is always beneficial because liabilities go to the corporation and not to any individuals as well. You can list office addresses, and you can also list states of incorporation. Again, this makes it a bit user-friendly to the extent, hopefully not, there's an issue down the road. We know right off the bat where each party is incorporated. And remember, just because you're headquartered in one state doesn't automatically mean you're incorporated in that state. A lot of you, for example, might be incorporated in the state of Delaware but have offices in other states. That simply means you're known as a, quote, domestic corporation in Delaware, and in New Jersey, where your home office is, that's you're a foreign corporation, which I know the term sounds strange, but it simply just means that you're incorporated in one state, but you're doing business in another state. So just keep those terms in mind. But again, an introductory paragraph, for the most part, a lot of us might look at it and say, it's just the introduction, and maybe our eyes skim over it. There are definitely some important items here to note, as I've mentioned, to go through. So looking at the next slide, the second portion of the contract is really the recitals. And some contracts you will see these recitals, and sometimes you won't see them. And honestly, it's a drafting preference for you or your legal eagles as to how you want to set these up. The recitals are essentially the story of the contract, why we're doing the contract. So you see these recitals, for example, and tell that story, tell a story of the seller having products that the buyer needs, etc. So these recitals can be kept in the contract, but they aren't required. So again, sometimes you'll see in drafting statements like this. Sometimes you'll see just a sentence or two that sets up the story. It is important, particularly if you're putting a new contract in place with the customer that's going to supersede a previous contract, having recitals or at least noting that this agreement supersedes and replaces that other contract is a good idea. So having the recitals in there important. You'll see still here some whereas and now therefore, etc. Some legal eagles like those, others don't like those. Honestly, from a enforcement standpoint, they really don't necessarily make a difference. But again, when you see these, obviously, if you're looking at somebody else's contract and you're seeing recitals, just make sure they're accurate, they reflect what's going on. If they don't, then obviously I'd want you to modify them to make sure they reflect what's going on. If you think they're just completely not applicable, then I would request that those provisions be removed from the contract. So pretty straightforward here, but there again, something to really pay attention to as you're looking at the contract to make sure it's accurate. Now, the meat and potatoes, so to speak, in these contracts, so the reason why we're doing them is because we want to document the sale and the purchase of products. So this is really the thrust of the contract, why we're actually contracting. And you know, just going back, that term contract is really a term of art. It means that this document meets all the requirements of a contract in order to be binding. So it's in writing, it's signed by the parties have authority to sign on behalf of their companies, et cetera. So, you know, keep that in mind as you go through the contracting process as well. So in this paragraph, we're really referencing to the products which are being purchased, and I recommend doing so by way of an attachment, so an exhibit. Exhibits are helpful because you can attach a document, maybe it's a purchase order, for example, that details the products in the way that you might typically detail by product number, type, quantity, etc., in some detail, or allows you to pull out of the contract those specifics so that the contract itself is reflective of the legal terms, and the meat and potatoes, or so-called nuts and bolts, are in the attachment. So if you take this strategy, and it is one that I would recommend, make sure you properly refer to your exhibits. So some people call these exhibits, sometimes you'll see these called addendums, sometimes you'll see them called attachments, whatever they may be called. Just make sure that it's appropriately referred to in this section, because that reference is going to tie the two together. So we want to do that tying. It is important, going back to the exhibit, that we detail the products as much as possible. So whatever that may mean with regard to your products, I would say be as specific as you can. Product numbers, serial numbers, types, you know, grades, colors, pricing, quantities, etc. The more specific you are, the better. It would certainly, we all want to avoid a circumstance in which one party thinks they're buying something and the other party thinks they're buying something else. So we have to definitely have that meeting of the minds, and so putting that detail in there is important. Sometimes, for example, you can include pictures. You can include a proposal perhaps you've made to a customer. I've seen those attached as well as exhibits. So all of those would be appropriate. The bottom line, we're setting up in this contract the definition of what we're calling products, and that becomes an important defined term which is attached to Exhibit A. Next important, perhaps more important to the products themselves, is how much we pay for the products, how much our buyers are paying, and how much our sellers are collecting for the products. Here again, sometimes I see this whole schedule, this whole provision be listed in the contract as a separate exhibit. So for example, this just might say, you know, the parties agree to that the purchase price and payment schedule is defined as an Exhibit B, let's say. And a lot of times it will be, all these terms will be parked inside that exhibit, similar to what we saw with how products are defined. It can really be drafted either way. I think a couple important principles to keep in mind. Remember, it's always easier to argue about money when you're holding it than when they're holding it. So some of what's in here, as you see, are strategies with regard to payment schedules. So whether you're buying the products or whether you're selling the products, it's important to understand what the total price is going to be. But it's also important to understand what money comes in the door along the way. If it isn't paid for in full, say within 30 days, if we're breaking out payment schedules, then we'll always want that money to come in the door. If I'm buying a product, I don't necessarily want all 100% of the money to go to you until I get the product to make sure it's working for me. If I'm selling the product, then I want to make sure I'm collecting as much money from the buyer in order to let that product be sent to that buyer. So sometimes it's helpful to tie these to either a date timeline. Sometimes it's helpful to tie them to milestones such as a delivery of the product, inspection by the client, approval by the client or the buyer. Any of those could be appropriate milestones to put in there. So this is going to depend on the types of products that you're selling, and of course the types of products you're buying, but making sure that you have this set up in a way that makes sure that we're never terribly exposed in terms of the payment schedule as well. So important to detail. Also, I know a lot of you deal internationally with clients and customers. Obviously, very important to refer to the type of currency that's being used in any given instance. All right, well, let's, speaking of the products and the pricing, now we'll talk about how I get the products, what the terms are for delivery and shipping instructions, as you see in the next slide as well. You know, the delivery and shipping instructions are obviously very critical because, for among other reasons, they talk about how the parties can fulfill their obligations under the contracts. So for the seller, it's how I fulfill my obligations in terms of shipping a product to you as a buyer. And as a buyer, it's telling me what responsibility the seller of the products is giving as they send the products out the door. So key provisions, and it's important to understand, as a lot of you I know do, the concept of when liability in that freight changes. So you also see the freight on board, FOB, with a city name, let's say, in there. That city name really talks about where the liability transfers from the seller of the product to the buyer of the product. For example, if the FOB is Jersey City, New Jersey, where your factory is located and it's going to be shipped out of, then that means once it leaves your plant, it becomes the buyer's responsibility. If, on the other hand, you ship a product to New York City, New York, if it says FOB, New York City, New York, then that means that the seller's responsible for that product all the time until that arrives in New York City, New York. So understanding a city, the origin of destination is important. There are responsibilities on the seller, of course, when they're responsible to get the equipment there safely. When a buyer receives equipment, obviously that equipment should be documented in terms of its condition. So I'm sure many of you have either seen damaged equipment come across, either sent back to you, or heard from a customer that equipment is damaged. Obviously, we want to know essentially when that damage occurred, because if, for example, the liability transferred in Jersey City, New Jersey, when it left my factory and it arrived in New York City and it was damaged along the way, that's really the buyer's responsibility. Obviously, we want to make good on a customer service and we want to fix it, but sometimes it's important if a buyer rejects a shipment, they actually might be rejecting a shipment that's already theirs because of this FOB concept. So keep that in mind as you talk about that in the contract. A lot of you, I'm sure, have policies and you work with shipping companies in terms of delivery issues. But this provision really should be customized to fit what your company is doing. There's obviously times when there's a delay in shipping that neither party can control. So, for example, with the hurricane or a snowstorm, et cetera, there may be delays in shipping. That's addressed in the clause. If you see the last paragraph of the clause on this page talking about seller not being liable for or responsible for delays for things beyond their control, such as acts of God. Sometimes delays are caused because a buyer gave the seller inaccurate information. So that's addressed here as well. I think bottom line is, don't ever make yourself responsible for something, a risk that you're not willing to control. So we really have to understand, and our team needs to understand how products are going to be shipped and who's going to be responsible at any given point for that product. And really understanding that whole process is important. Obviously, we're going to be answering questions of buyers, so making sure everyone on the team is consistent with this process is important. I wouldn't recommend editing this process unless we're prepared to edit it in a way that we think we'll use across the board. Because I often say to clients, when you make exceptions to your normal business practice, it's that exception that likely is going to come back and haunt you, right? It's that 9 times out of 10, it's all good, and the 10th time. So again, just be careful with any modifications to this provision. A related point is the storage of the products. So here again, if a buyer doesn't make arrangements for shipment of a product and we're storing it, we the seller are storing that product, we want to make sure that once it's stored, we really tell the buyer that it's stored at their risk and it's at their cost. So this should motivate a buyer to make arrangements for shipping as soon as possible. This is something, this is one of the provisions in a contract, an example of one where it doesn't hurt to have this clause in the contract, because even, if it doesn't come up, great. If it does come up, we at least have a remedy. We have a way to say, hey, buyer, under this provision of the contract, you're responsible for the risk of storage and you're responsible for the cost of storage. So it's in there in the, in the event, in the rare chance, if you will, that this issue comes up, here's what will happen in terms of storage of products. Speaking of just this provision and kind of explaining it in the way I did, I think it's important for the sellers and their sales teams to really be able to explain certain provisions in your contracts in a way that, tells the customer, tells the buyer why we have certain clauses in there. I think it's just good to have a working knowledge. I think certainly from a buyer's perspective, if they get a contract and they say, hey, seller, what does this mean about storage of products? We need someone who's able to explain it in a way that's easily understood. And sometimes that might mean making a modification to the contract clause in order to make it user-friendly for that particular customer. So again, if you're going to change the clause, always recommend running it past your legal eagle. But sometimes it's really just a manner of clarifying certain things so that the buyer feels comfortable with that. Now, a situation that we're uncomfortable in is when either party does something that they're not supposed to do, or sometimes doesn't do something that they're supposed to do. This is known as default, or sometimes it's called breach. So, of course, under the contract, there are various responsibilities of the seller of the products and responsibilities of the buyer of the products. So if there's a circumstance in which the seller doesn't provide the products in the timeline that it said it would, arguably it's in breach of the contract with the buyer, and the buyer can exercise its rights under the contract language under default. So, for example, this clause shows you an example of what I would call a breach of contract provision, or a for-cause termination. So you see in the first paragraph that we talk about a default by one party. We set up a requirement of a process, and the process is that the party who's not in default, so let's say in this case it's the buyer has to give notice to the seller, hey seller, you were supposed to deliver this product by May 1st, 2018, and it's now May 29th, and the product still hasn't arrived. You are in breach of the contract. Now, usually what this does is it starts the time clock ticking, because the party that's in default, in this case the seller, they have an opportunity to correct, or sometimes this is called cure, a default. And usually it's a certain period of time that's given. The period of time can really vary significantly here. I always tell clients that, the number of days I would fill in here are related to the issue that might arise. For example, how long would it take you to fix the product, or how long would it take you to ship the product, giving yourself some wiggle room. So it's important, a couple principles are important here. First of all, documentation is very important. I'll often talk with a client who will say, they'll call me and say, you know what, I bought this product 2 months ago. They said they'd ship it a month ago, and they still haven't shipped it. And I'll say, well, did you send them notice? Well, no, we talked about it on the phone. That's certainly fine, and I'm a big fan of the phone, used as a phone vehicle to communicate with one another. But I also want to make sure that you're documenting this in writing. So it's important to document in writing, even if the writing is a simple email trail, recording the fact that, hey, Fred, you said the product would be here by May 1st. It's now May 5th, and it's still not here. What's going on? And we start that process going. And if that process continues, it's really important at some point that we say, we are invoking our rights under the default provision because you're in breach. Now you have, usually it's X amount of days, let's say it's 10 days from the date that the defaulting party gets your notice. They have 10 days to fix it and get it to you. So it starts that clock ticking. If they can't deliver the products in that time, in my example, then that would be an excuse. You would be able, the buyer would be able to terminate the contract without liability. So, and that also means if they had paid the seller a deposit for the products or made a prepayment, they would be entitled to get that money back. So it's a messy process to say the least. But one common thing that I find is that, you know, you all have heard the saying, I'm sure, no good deed goes unpunished. Well, you know, a lot of times, whether it's the buyer needing time or the seller needing time, we grant the time, and yet we sort of, you know, give an inch, take a mile type thing, and then, you know, we find ourselves in a circumstance where we've allowed a breach to continue and we haven't documented the breach. So it's very important to do this. This doesn't mean, you know, that you're mean and nasty and you're going to terminate the contract. It's just really a formal process to invoke that. And as you see in my note, every contract you sign, whether it's a contract like this for a sale of products or whether it's a contract to hire a landscaping company to work on your building, every contract has to have an exit. Just like every room has an exit, every place should have a public exit, that sort of thing. It's a safety issue using the term exit in that way. The typical exit is because of breach, so because of default. This provision also refers to the ability to exit if one or the other party makes some formal filing toward bankruptcy. The caveat with this one is depending on the status within bankruptcy or reorganization. Some parties, you may be foreclosed, you may have to hold on, so to speak, while it goes through that process. So keeping that in mind, bankruptcy can vary on that point. But also, you could have a right to terminate the contract for no cause, for no reason. Sometimes this is called for convenience, which seems like an odd term. But basically it's saying, you know what, I bought some other products from you. It's not a breach, but I'm just not liking them. So I don't think I want to buy these other products from you now. So it's not saying there's a breach and we start the clock. It's rather saying, I'm giving you notice that I want to terminate the contract. So typically when you talk about a for-cause termination, you know, we talk about a window of time to fix a breach and a relatively short window of time. When we talk about a termination for no cause or convenience, typically we're setting up a longer period of time, let's say 30, 60, 90 days. We want to be fair to the other party to let them know well in advance of when we want to terminate a contract. Again, this doesn't mean we're avoiding paying for what they gave us and all the rest. That would all still be due, but it is a way of walking away. So I encourage clients to really think about exits in both of these ways, exits for a breach and exits for no cause or convenience. Again, my experience has been when I talk with a client, it isn't so much that the other party is in breach, it's more so that we just don't want to work with them anymore. And unfortunately, there's not a clause in the contract for that unless we build in that for convenience clause. And the road can run both ways. If we're the buyer and we want the right to terminate, our seller might want the same thing in return. If we're willing to grant it, then I would say the contract would reflect that we'd be willing to grant it both ways. So this clause is important, and again, most important is documentation. One other note here is that sometimes you see reference to material breach. So before the word breach, you see material, or you'll see breach of a material clause of the contract. You know, the term material really means whatever you want it to mean. It's a very pliable term. And, you know, my recommendation on either side is really, I don't like the term. I don't want to have to argue something is material or isn't material. For example, the product itself, you know, the type of equipment, I would say that's a material fact of the contract. That's why I'm doing it. But you might say, well, just because we produced it in orange and you ordered purple, that's an immaterial fact. You know, it may be material, it may be important to us. So I'd rather avoid the argument about material or not and just simply stick with the breach itself. All right, so moving forward, couple things now in terms of some risk management principles. And just to set the stage here, there are a number of ways that you as a company can manage your risk. We can always certainly avoid risk. So if we're concerned, for example, about a product liability claim on a piece of our equipment, we're going to do our best to make sure that equipment is safe and compliant. That's an example of risk avoidance. It's practical things we can do to make sure the, quote, bad thing doesn't happen in the first place. So risk avoidance is always important. Also, having insurance is important as well. We'll talk about that on another slide coming up here. But the other I word to always remember when it comes to risk management, in addition to insurance, is indemnification. This word is a mouthful, and sometimes it's known as held harmless or hold harmless. Basically, the gist is this. I pay you to do a job. I expect you're going to do that job right. If you mess up and I get sued as a result of you doing something wrong, I want to be kept whole from a financial standpoint. That's that concept of held harmless or hold harmless. So if a piece of equipment is sold and something goes wrong with that equipment and people are hurt, the indemnification granted from the seller to the buyer basically says, hey, buyer, we'll indemnify you for certain things. So, and this is where we can talk about the language itself. So it's a way to shift or give risk to a party which can best control risk. So always think about this as your example. As between the seller of equipment and the buyer of equipment, which party is in the best position to make sure the equipment is functioning properly? The seller or the buyer? Typically the answer is the seller. They design the equipment, they produce the equipment, etc. You could argue sometimes, hey, it's the buyer too, because they install it and they may be using it improperly. Absolutely, that may be the case too. So often indemnification is set up to be mutual. So the seller is agreeing to indemnify the buyer, and the buyer is agreeing to indemnify the seller. So let's look at the clause here and just kind of understand some of the terms here. And by the way, this is one clause that I would say I would not want you to modify unless you talk with your legal eagle first, because one word does make a difference. So let's look at the first paragraph. When seller agrees to defend, indemnify, et cetera, the buyer. That word defend is a really good word. If I'm the seller, the word defend is a good word, because that means that if the buyer messes up and I get sued alongside them, they will defend a lawsuit against me. So they will pay my lawyer's fees day one, $1. It's that affirmative obligation to defend the lawsuit. If it didn't have the word defend, the net result is to say that the buyer would reimburse the seller day 61, $600,001. So it's that obligation to pay off the bat versus a reimbursement context. So you'll see this word defend. Sometimes you'll see defense cost thereof. Sometimes you'll see defend with legal counsel of seller's choosing. There's a lot of different ways this can be put together. As I mentioned, what are we protected from? This is typically where you see these lettered or numbered spots. So, here in this paragraph, we're claims arising out of failure of the products to meet specifications, seller's negligence, so we did something wrong or we forgot to do something, and then the seller's breach, so we didn't provide the product as contracted. This also provides an example of a circumstance that the buyer would agree to indemnify the seller. So in this context, again, we're talking about if there's a claim because, let's say, the buyer didn't install the product appropriately or the buyer was in breach of the terms of the contract. So these provisions vary, but they essentially mean take responsibility for the responsibilities or portion of the contract that you're doing. If you mess up and we get sued, you are to hold us financially whole, keep us financially whole. So it's an important concept in risk management, and it costs you nothing. it costs you the time and effort to negotiate it in your contracts, which is why I think it should be part of every contract. And again, there's lots of different flavors, there's lots of bells and whistles that can be put in here, but the concept should always be present in the contract. The last line you'll see here is just a statement that says, hey, once the contract's done and performed, I accepted the products, I paid you for them, etc. If something comes up later, this provision, indemnification, that will still apply. Sometimes in contracts you'll see this statement included with indemnification. Sometimes you'll see a separate clause that says survival, and it will list the sections that continue after the contract is terminated. A couple of those that we'll talk about, but indemnification is typically one of those. So shifting over now, we're getting into some of the boilerplate here as we get into parts of the contract. One concept here on the next slide is regarding successors and assigns. So if either company, buyer or seller, their company is bought out, let's say, prior to the products being delivered or the products being paid for, this clause is really intended to say that, you know, the same legal parties in that introductory paragraph that signed it are the same parties that are bound to this. But that also means that if I buy the seller, I now step in the shoes, I become the seller, and this contract applies to me. And the same would be true on the buyers. So sometimes when it comes to a seller, you know, I'm a buyer of a product, I want to make sure that it's this particular seller, not some company that bought them, because I like the way they design products. I don't know if the other company would design them that way. So a lot of times you will see this statement here about seller not assigning its rights or privileges without the prior written consent of the buyer. So that's a bit of a stopgap for the buyer in case the seller's sold. Usually, if it's the opposite, if I'm the seller or the buyer's been sold, I might be okay with that. But some contracts talk about neither party can assign without the other's consent. And a lot of times you'll also see, you know, except if it's assigned to a wholly owned subsidiary company. So this clause is important. A lot of times I'll get a call from a client and they'll say, hey, you know, I just got notice that this company is sold and I'm buying products for them. You know, the new company is saying I have to sign a contract. Well, that may not be true depending on what this clause says. So that's why this clause is important as well, making sure you have it in the contract. Shifting over is a concept that we've already talked about a little bit in the confines of delivery, and that's the concept of force majeure. This is typically referring to causes beyond the party's control. So if any one of these causes delays or prevents a party's performance, whether it's delivering a product or whether it's paying for the product, that's what this clause does. It's an excuse, if you will, to not perform a contract. In this case, we typically list all the various calamities or bad things that could happen that might justify a delay in performance. And this is just an example of one clause. You can modify this clause certainly in a way that makes sense for you or your company, but certainly acts of God relative to weather, fire, flood, etc. All common things. Sometimes we're talking about strikes, sometimes we're talking about attacks, limitations, etc. It's going to really depend on the circumstance. But basically this clause says if either party is impacted by one of these events, we have time to extend the contract. In this example, we talk about it if it persists for more than 90 days, then a party would be excused from the contract. So basically everybody's in a bit of a wait and hold pattern to see what will happen. So this clause benefits both parties because both parties' performance is contingent on that. If I'm buying a product and my warehouse gets flooded before you ship that product, I want to tell you don't ship it until I get things remediated. Same is true if there was something affecting a seller's plant and there was product delayed. So this is typically a clause, really you'll see this clause in most every type of contract, and it's really just set up to state what we would assume would be the obvious, that if something happens beyond our control, that would give us extra time. And that's really what's provided for in this clause as well. Moving on, because obviously being the sale of equipment, it's likely expensive equipment. Many of you may look to have a security interest in that equipment if a buyer makes a portion of the payment of the purchase price, but not all. So some of you are familiar with the Uniform Commercial Code and the filings that are required to what's called secure your transaction as well. This language is pretty standard, I would say. Usually there's not a lot of bells and whistles here. The key with these UCC filings is that they're filed with the state, so they secure that transaction. And the collateral is typically the equipment itself. So again, whether you're involved in this aspect or your legal or finance people are involved in this filing, this is something that just putting in the contract is important to have, so it lets the parties know, hey, these are the rules that we're going to play by. And another rule we're going to play by, which is important to customers, buyers, would be the warranties. This provision is something that's definitely going to be customized from your company, your department, maybe even specific, of course, to every type of product. So again, we're not really saying, these are the parameters you should have in your warranties. What we would be saying, though, is you want your warranties to be as complete as possible. So it's typical, for example, you would see terms and warranties such as the seller producing the work in a good, workmanlike, and professional manner. And you see products are highest grade and quality, etc. So there's a lot of basics in here with the warranty. But sometimes, sometimes I'll joke with a client and say, if you're having trouble sleeping at night, curl up with the warranty that came with something you bought at home, whether it's a TV or whatever, refrigerator. They're written in 4-point font, gray font that is crazy ridiculous to read, but that's essentially what each party's rights and responsibilities are. These are important to the customer, so certainly I recommend, from a seller's perspective, making your warranties user-friendly as possible, putting them in small, manageable bites, and how we break it up so it's not one long run-on sentence, whatever strategies that you use. But it is important to communicate what the warranties are with regard to the products that have been sold. And of course, if I'm the buyer, that's a question I want to ask right off the bat. So I want you, seller, to be able to share with me what the warranties are for these particular products. Moving into the other I word I mentioned a few minutes ago, in addition to indemnification, is the concept of insurance. If I'm a buyer, I'm going to want to know that the seller has insurance, because the seller made a commitment to indemnify me, if you'll recall, and really the financial backing behind the promise to indemnify would be their insurance. So often your company, for example, if you're a buyer, might say, hey, we won't buy products from any vendor who doesn't meet these threshold minimums, whether it's workers' compensation insurance, general liability, any of those. We have to make sure our sellers are vetted. Some of you may vet your sellers through procurement and have a verified seller list. Other of you may do this on a one-off basis. But making sure that there's coverage. And the buyers want to know there's coverage. They want to have you prove it by way of showing them a certificate of insurance, and sometimes even ask you to name them as an insured on your policy. So that's that concept of additional insured. Sometimes you see that referred to as co-insured. That's likely not applicable on the workers' comp insurance, but it would be applicable on the general liability policy. So, insurance is a way we manage risk. It costs us something. It costs us the premiums that we pay for insurance and any deductibles that we have, but it's an important way to cover risk. So some insurance clauses and contracts are more detailed than others. I think from the seller's perspective, though, putting, in your contracts what type of insurance you carry, it just makes the buyer feel better. They know what kind of insurance you have in place. And some of you who might be with a very large company, you may be self-insured up to certain levels or limits. And so there again, the contracts reflect those types of provisions in here as well. And then shifting on down the line, and I would definitely encourage you, if you have questions, please go ahead and start typing them in. We'll go ahead and take as many of those as we can in just a moment. Looking at the situation, we were talking earlier about responsibility and delivery. So here's really what the process would be if there was a claim or a defect on a particular piece of equipment. Again, documentation is important, whether it's photos, whether it's videos. Also, time is of the essence. So we bought a product, we paid for it, it got shipped, it's not working, time is of the essence. So both parties need to understand what that clock is running. And sometimes it's an issue that doesn't arise for a period of time, 60, 90 days, let's say, after delivery. But whatever the case, and of course, depending on the corresponding warranty, this claims and defects procedure should be in all of your contracts. So everyone understands. In fact, one thing you'll see in here benefiting the seller is the third paragraph in this provision, which states that the buyer waives or gives up any right to make a claim against the seller for nonconformity, which would have been, seen at the time of inspection within a certain time frame. So the good thing is it puts the buyer on the clock to tell you about things that are obvious to them. It should have been seen by them. Things that were, interior, not necessarily able to be seen by them, wouldn't necessarily apply. And also important for the seller, you'll see on the next two slides, is the limitation of liability. Here again, your legal eagles draft these clauses, help to protect, they help to limit the seller's liability for damages. So that's essentially that term, limitation of liability, is directed from the seller to the buyer. So your buyers are going to look at this clause and they're going to want to make sure that they're not terribly limited on damages that they could recover from your company as a seller. So you see a fair amount of this provision is in all capital letters. That's not done just because of crazy formatting. In order for these types of clauses to be enforceable, they have to be conspicuous. So sometimes that's all caps, sometimes that's bolded, sometimes it's a text box. Any of those types of things you'll see, that's why they're in that language, why they're in all caps or why they're in bold as well. So usually what we see is that certain types of damages are excluded. For example, incidental or consequential damages. So this might be, the machine I bought from you didn't work, and as a result of that, I lost my biggest customer. That might be an example of an incidental or consequential damage, which would not be recoverable under this language. And then there's other damages which essentially would be capped at a certain amount that's paid for the product. So a lot of times it might say, our liability to you, buyer, is capped at what you paid for the product. And the buyer might say, well, gee, I don't know, if this product explodes into something really bad, our liability is going to be greater than that. So sometimes we reference to, it's limited to this dollar amount unless it's something that's covered under indemnification. So buyers are going to want to negotiate on this clause a little bit because they don't want the ceiling to be too low. And obviously the sellers don't want the ceiling to be too high or not even exist, which is why we have this clause in here. So again, empower your team to understand the clause, understand why it's in here, be able to field questions from clients, and if changes are requested, that you have an internal process with your legal to review those as well. And then just closing out, a couple of provisions in that contract you'll see sometimes. One dealing with confidential or proprietary information. So confidential information is usually it's information that's not publicly known. It may be marked as confidential. Proprietary information actually has a value. So the recipe to Coca-Cola, example of proprietary information. So when we exchange goods and services, buy products, sell products, along the way there can be confidential information that's provided. It might be sales data, it might be performance data, it might be patent designs, it may be a number of different things. And we're basically saying between the two parties, with the data we exchange, we're going to treat it as confidential or proprietary, and we're not going to share that data with anybody else. And the exceptions here are typically data which, or information which, is already known in the public domain. So everybody knows that this product only comes in black, or is lawfully given, by the receiving party, already received it from someone else. Again, or it's been published before. So these are typical exceptions you see. Confidential information is important because it impacts not only what the point person in the contract does, but it's everybody else on your team. So understanding that a lot of your contracts may be locked down with confidentiality clauses and training your staff to know that they're in here is important, because it's easily that the staff may be requested to provide information that is confidential, and that is a problem. So seeing this continue into the next clause, again, this is something that can be customized. And as we round out, just some final boilerplate du jour, the first being dispute resolution. Again, this is a conversation you'd have with your legal eagle. Usually I always recommend this first paragraph, which is this, what I'll call a 30-day cooling off period. So if we're having a dispute back and forth, let's at least give each other 30 days before we invoke our rights under the contract. Now, this doesn't apply to the breach situation. This might apply to, hey, I got the product and it's wrong and you guys aren't doing anything about it. We're going to sue you, right? And so we get into this 30-day period. Sometimes your legal eagles want to have disputes resolved by arbitration or mediation. So any of those services that would be provided under the contract. And typically when we talk about mediation or arbitration, we'll put in this law of the state that would apply. Clients will ask me all the time, which is better, which is worse. It really is, honestly, to pick your poison. And I would say that, defer to your legal eagle to guide you on that as well. The same is true for choice of law and forum. Again, choice of law, as I mentioned, you may be incorporated in Delaware, but you're doing business in New Jersey. So is it going to be state law of New Jersey that controls, or maybe it's Delaware? And where is the litigation going to be heard? If we don't agree to mediate or arbitrate, then it goes to Judge Judy. and that, where is that going to be? What court? So usually we note that by county or city. Keep in mind, you all are dealing internationally, so sometimes you will have someone want to have the home court be their own country, which, again, something to talk about with your legal eagle. One thing I recommend in those circumstances is that there is an international arbitration center with different locations, but one being in London, the UK, that sometimes provides a good middle ground for parties on resolving a dispute that's international in nature. So again, that's something to think about or talk to your legal eagle about if you're doing it internationally. And then just rounding out these provisions, waivers. This is something you've probably seen in the contract before. Just because I say, hey, you delivered it to me on the 31st day instead of the 30th day, that doesn't mean I can't hold you to another obligation under the contract, like the product working. So that's basically just stating that concept of waiver. But if this ever got thrown in your face, so you all allowed late payment, for example, and now I don't owe you the other payment, this is exactly why this clause is in here, to say, look, we might have waived it for one, but that doesn't mean we're waiving it for all. Severability, this just simply means that if there's one part of the clause, one part of the contract that's too broad, it gets thrown out, can't be enforced, the rest of the contract still survives. So let's say my confidential proprietary information clause is too broad. The court might throw that out, but the rest of the contract remains. Also, section headings. Some of you have headings. Some creative lawyers like to say that the heading, supersedes what the contract says. Again, this is in here to prevent against that. And then you'll see typically these clauses toward the end. Entire agreement, you'll see this reference. This is important because it basically is saying everything that we talked about in writing or in person before is now evidenced in this contract, and we want to refer to all of our attachments. If there's anything that isn't up to this point, it's not binding. So this clause is really designed to capture everything in there. So be very careful that you're listing the exhibits out here. That does become important as well. Some of you might have terms and conditions as well that you might attach. Sometimes I see these attached as a link, in which case I'd always say I'd want to have a copy, hard copy printed, so we understand what those terms and conditions were at the time the contract was signed. And then just noting on signature with regard to counterparts that, we may sign a couple different copies, all versions are valid, provision regarding mutual negotiation, simply saying that, both parties negotiated this contract, so it shouldn't be construed against either party. Knowing that you sign contracts electronically now, some of you may see the word facsimile and may not recognize a fax circumstance, but those of us who've been around, we trade signatures a lot of different ways. This is simply saying whether it's a hard copy, pen to paper, whether it's electronically signed, it's binding on the parties. And then the last provision is just your signature line. Again, making sure the same company names that are in your introduction are in your signature line. And the person who's signing them, of course, has authority to sign the contract, and they give their title as well. So I know we've covered a lot of ground here. Love to have any questions that you have. And as Dolores mentioned, we'd love to be a further resource for you or your company through our legal service program, so please let us know. Dolores, with that, I'll turn it back over to you to see if we had any questions.
Great. Yes, we do, Barbara. The first one is from earlier on, I think the second or third slide. It is, can the quotation for goods sold be used as Exhibit A, good or bad practice?
Yeah, I think as long as Exhibit A, what we're referring to as goods sold, is detailed in terms of defining the products and the type and the pricing and all the rest, sure. I think that would be fine. Again, make sure sometimes we're all busy and we might put the same attachment on one contract we use for another, and it may not be the one that matches the situation. So always having that extra check in the process before you attach something is a good idea.
Great. Thank you, Barbara. Second one regarding indemnification. Is it standard to have all indemnifications limited in some way? We struggle with getting our customers to agree to limit our indemnification requirements.
Yeah, it's a reasonable request to ask to be indemnified, and it's reasonable for the buyer, the customer, to want to lift the limits off of indemnification. So what my recommendation would be to sellers is, I would never want you to start indemnifying the customer for something, for a person or a situation that we can't control. So in other words, we can control what our employees do. We can control what our contractors can do. Can we control anybody who might walk into our plant or factory? No. So sometimes trimming these clauses down does become important. The other message to the clients, the customers, is to say, just because you don't have the indemnification clause exactly as you want it, doesn't mean that if we mess up, you can't sue us. You can sue them. It doesn't waive and give up the right to sue. It simply talks about the affirmative obligation to defend another party. So I would say, understand from your legal eagles where you might have some room to maneuver. I think it's a good strategy, because if a customer raises an issue, you'll at least be able to provide some alternative. And at that point, it may be up to the two legal eagles to sort of duke it out. But I've always been able to resolve indemnification in one way or another. So hopefully that will be the case with you as well.
Great. Thank you, Barbara. And finally, is a sales contract enforceable outside of the U.S.?
Well, I'm going to give you my famous two-word answer to close our webinar. And that answer, some of you may already say this, is it depends. It depends on who the parties are to the contract, what's anticipated with the performance of the contract. So, for example, let's say the company that's the buyer headquartered overseas, and the equipment may be delivered both in the U.S. or outside the U.S., it's anticipated that that contract would apply in those other countries. So I gave you an example a little while ago about the type of dispute resolution. That type of contract we would want, this international arbitration for. Hey, arbitrator, in our contract we agreed that the laws of the state of New Jersey would apply. And so, yes, it's very conceivable that a judge in Germany, who's looking at a contract for sale of goods in the United States, would and could enforce that agreement. But why, arbitration might be important outside of the U.S., inside of the U.S., again, pick your poison, let your eagle, tell you what they like better. But outside the U.S., I think arbitration is a better strategy because it does take out the variable of these various sort of home countries and puts it into the hands of one arbitration process. But that choice of law, New Jersey law, that would still apply even in an arbitration setting. It would be an arbitrator using the concepts of that state law for that particular arbitration.
Terrific. Thank you, Barbara. I think that's all the questions we have. We want to thank you so much for all of this incredible detailed information. And for the members, if you have any additional questions that you'd like to ask Barbara offline, her information is up there on the slide, and she'd be happy to answer those for you. So once again, everybody, thank you so much for joining us today, and we hope to see you soon. Thank you. Thank you, Barbara.
Thank you. Thank you, everyone. Have a good day.